Hello and welcome. Today I'm taking a look at the eviction process in Pennsylvania. It's a topic that's often packed with crucial information for both landlords and tenants. Understanding this process is very important. Are you ready to dive into this important subject? Let's get started. The eviction laws in Pennsylvania differ slightly from county to county, but the eviction process stays fairly the same. Send a clear written notice, fill out the forms, serve the documents, attend the trial, and wait for judgment. A good landlord-tenant relationship makes the process easier because there may be no need to file a complaint to the court for an eviction action or an eviction lawsuit. Leases also allow landlords and tenants to have special arrangements in case there are disputes regarding a lease violation. Sometimes a lease may indicate no notice is required prior to proceeding with a legal action. This video is a summary for landlords to refer to when evicting a tenant. Alternatively, a landlord can ask attorneys for legal advice if they have any questions on the Landlord-Tenant Act or on their county's eviction rules. Get the Guide to Eviction Laws on the go from DoorLoop's Landlord's Guide series. Click the link in the description to get all of our best tips. Remember, if you find yourself in a situation that you're unsure of, seeking legal advice is always a wise decision. Now, let's dive in. Eviction reasons. Notice requirements vary depending on the reason for evicting a tenant. Pennsylvania law requires the landlord to comply with notice requirements, and the notice must have all necessary information, such as the tenant's violation and how long they have before they must vacate the rental unit. The notice must be presented before filing a complaint in court. If the lease stipulates no notice is necessary, then the landlord can proceed to the next step. Failure to pay rent or non-payment of rent. The most common reason for eviction is failing to pay rent on time. A landlord may evict renters for non-payment of rent. Rent in Pennsylvania is considered late a day past its due. Before a landlord can start filing an eviction, the landlord must give the tenant a 10-day notice to quit. This eviction notice allows the tenant 10 days to settle any unpaid rent. The tenant must resolve their non-payment of rent after the 10 days notice, or leave the rental premises. Otherwise, the landlord may continue filing for an eviction action. Violation of the written lease or rental agreement. A written lease agreement can vary between tenants. Both the landlord and the tenant must uphold the terms of the lease or rental agreement at all times and avoid lease violations. In Pennsylvania, the landlord can evict a tenant for violating the terms of the written lease agreement. The landlord must provide an eviction notice called a 15-day notice to quit for at-will tenants and other tenants who have resided in the rental property for 1 year or less. Tenants who have resided in the rental property for more than 1 year receive a 30-day notice to quit. Should the tenant fail to move out within their given notice period, the landlord may continue filing for illegal action. Conducting illegal activity. If a tenant has engaged in illegal activity on the property, the landlord must give a tenant a 10-day notice to quit before filing for an eviction process. Examples of illegal activity are violating the Controlled Substance Act of 1972 for the second time. Law enforcement officials seize drugs from the tenant's rental unit. Involvement in the creation, distribution, or consumption of a controlled substance. Non-renewal of lease after the end of the rental period. A Pennsylvania eviction process does not allow a landlord to evict a tenant without good cause. The landlord must either wait for the tenant to commit a violation or wait for their lease term to end. Tenants who stay within the rental premises, even a day after their term ends, may be evicted. The notice a tenant receives depending on their tenancy or lease term, which can include a 15 days notice to quit or a 30 days notice to quit. For your own Pennsylvania lease agreement, click the link in the description for DoorLoop's forms page to download a template along with many other forms. Filing a complaint. The landlord may file a landlord-tenant complaint after the notice period has passed. The landlord can fill it out either before or during their visit to the Magisterial District Court or Court of Common Pleas in order to file it. Steps in filing. Proceed to the right magisterial district court or court of common pleas the rental property and reason for eviction belongs to. Fill out the landlord-tenant complaint form and pay the filing fees. Timeline. It takes between 10 to 30 days before a landlord can file a complaint. Notice to comply. Before filing for an eviction with the court, you need to issue the tenant a notice to comply. You can either download the free PDF or Word template, or create your Pennsylvania eviction notice by clicking the link in the description to use a step-by-step wizard that guides you through the entire process to make sure you are submitting the legally correct notice. Keep in mind, the step-by-step wizard will ask you to pay a small fee at the end. It's a small price to pay to ensure legal compliance and protection. The last thing you want is to go to court only to find out you did the first process incorrectly. Serving the tenant. The summons and complaint must be served on the tenant by a sheriff, writ server, or constable. How to serve the summons and complaint to a tenant. There are 3 methods available. The summons and complaint is delivered to the tenant in person. The server mails the document, and a copy of the document is placed in a secure and visible position by the entrance of the tenant's rented property. After serving the summons and complaint, the tenant is not required to file an answer once they receive the eviction complaint. Timeline. The summons and complaint must be served on the tenant before the eviction proceedings begin. Asking for possession. Filing a motion to obtain judgment and get a judgment for possession. The landlord must provide a strong argument backed up by solid evidence against the tenant in order to win. Should the tenant fail to show up to the eviction hearing, the magisterial district judge should rule in favor of the landlord by default. Valid evidence may include a copy of the deed and the lease or rental agreement, rent receipts and rent ledgers, and bank and witness statements. Attorneys may also represent tenants or landlords during the court hearing. Tenants who were victims of domestic violence can appeal the ruling within 30 days, but under regular circumstances, tenants only have 10 days to appeal. Timeline. An eviction hearing is scheduled 7 to 10 days after the issuance of the summons. Getting possession. After the landlord wins the case and gets a writ of possession. Once the landlord wins the case, they can request a writ of possession, also known as an order for possession from the district judge. This is a court order which informs the tenant that they must move out of the property. The order of possession is released 5 days after the landlord wins the case. Should the tenant be able to pay all court costs and fees before the order for possession is issued, then the entire eviction process is stopped. Move out process. The final step in the eviction process is to move the tenant out of the premises. Pennsylvania law dictates that once the writ of possession is issued, law enforcement officials have to serve it to the tenant within 48 hours from the time they receive it. Timeline. It takes 5 days from the writ of possession to be issued by the court. Law enforcement officials have 48 hours to serve this court order to the tenant. After that, the tenant has 10 days to move out of the property. Pennsylvania eviction process timeline. It takes an average of 1 to 2 months for a complete eviction process in Pennsylvania. Showing evidence. How to keep good records. If the tenant disagrees with the request to begin the eviction process and they reply to the court, it's important that you keep extremely good records of everything so you can provide proof to the judge and win your case. This part can make or break your entire eviction request in the event of a dispute. You can stay organized by keeping a physical paper trail. This gets very hard to search through, takes up a lot of storage space, and could get lost, damaged, stolen, or burnt in a fire. Scanning documents. Scan every document into your computer. Backups. Store and backup every file using Dropbox, Google Drive, OneDrive, or any other option that is easily searchable. And PMS. Use a property management software to save everything from lease agreements, signed documents, violations, emails, notes, invoices, payments, reminders, maintenance requests, pictures, videos, and anything else that can possibly be useful in a court case. This is used best when you also scan every document into your software. DoorLoop is a great example. You should check it out. Evidence to show for not paying rent. If the tenant doesn't pay rent and they dispute that claim, it's important that you show the judge the following: your lease agreement, showing the terms of the agreement, when rent is due, and any penalties for late payment. All payments. Showing all previous payments, how they were normally made, check, credit card, ACH, etc., and what date they were normally paid on can show that the tenant and the landlord had established some sort of schedule. Any payment returns. If their check bounced, their bank account had insufficient funds, or they did a chargeback dispute on their credit card, show this to the judge. Also show any fees your bank may have charged you and any penalties you are owed according to your lease agreement. And all messages. If you send your tenant automated or manual payment reminders by text, email, letter, or mail, it's important to show this. While it's usually not needed, it's still good to show that they were aware of the situation and were given time to cure and make payment. This is why it's always best to have everything physically in writing instead of any phone calls or face-to-face meetings. Evidence to show for lease violations. If you are evicting the tenant for lease violations, for example, noise complaints, unauthorized pets, or property damages, it's important to show proof from any of the following methods. Security cameras. If you have a surveillance system that can show them committing the crime or lease violation, you can be confident that the court will rule in your favor. Video. If you don't catch them in the act, the next best thing is to record a video with your phone of any damages or the lease violation. Pictures. They say a picture is worth 1,000 words. In this case, a picture could be worth thousands of dollars. Even if you take a video, it's important to show the judge any pictures too, as it's usually easier to see by email or printed. And lease terms. Once again, show the court which term they violated in their lease agreement. Don't worry if you don't have every single term spelled out in your rental agreement. If the violation is bad enough, it might not be needed to have it written. As a good practice though, start adding all of the potential reasons to evict a tenant into your agreement. I hope this information has been useful on this complex topic, helping both landlords and tenants to better navigate these situations. As always, please like, comment, and subscribe for more property management content. Also, check out these videos. Thank you for joining me today, and until next time.